right, ma'am.
Good morning. My name is Star Brookins, and I rise on behalf of the appellant, CD, in this matter. I would request 5 minutes for rebuttal.
All right.
Thank you. The court is here due to a matter arising out of the 13th Judicial Circuit, which is Hillsborough County, and this is a very distinct and succinct issue for this court. We're not here to challenge the conviction of CD. We're not here to challenge the adjudication of delinquency of CD. We are, however, focused upon the disposition and commitment of CD. And we would request that the court reverse the order of commitment and disposition, as well as remand for further proceedings if there is any evidence that could support that departure. However, if not, and if it would be beneficial to CD in that matter to get a new hearing. However, if not, then to conform with what was articulated in Bryant by the Flores Supreme Court, which is that after the fact justifications are not permitted. So if it wasn't presented, then the low risk commitment program recommended by the department should stand. And the appellate court in this case must determine whether or not the trial court abided by the proper legal standard and its on the record reasons. And that is directly from JH, which is a decision by this court in 2012, where Arose actually wrote that opinion, and it stated that that legal standard is something from EAR, which is first and foremost that the trial court must articulate an understanding of the opposing restrictiveness levels, and secondly, that the trial court must logically and persuasively explain why, in light of those opposing differing characteristics, that a departure is necessary.
But certainly the trial court could have been clearer, I agree with you. I mean, but it was clear from the context of her comments that she was frustrated with this child. She rejected immediately the DJJ recommendation as being too lenient. She recounted the child's continuing and escalating criminal activity and drug and alcohol abuse. She further recounted that he committed further new law offenses involving alcohol after DJJ had completed and submitted its predisposition report, and that he'd been unsuccessfully discharged from a substance abuse program at the Phoenix House for repeatedly breaking program rules. So she clearly had a basis to be frustrated, and she clearly indicated that the proposed level of supervision was not enough and that this higher level was required. How much more detail is she required to give?
Well, Your Honor, in EAR, it states that mere parroting or regurgitation of information already known by and considered by the Department of Juvenile Justice is not sufficient. It's not a legally sufficient reason in order to deviate, which is exactly what this court did, and which is exactly what the lower court did, excuse me. So that's very clear in EAR. The trial court in this case just merely parroted and regurgitated what was already known to the department, and so that's not sufficient. And this court...
But implicit in the trial court's recitation of the history, isn't there a finding that this child needs a more intense and a more structured environment? I mean, isn't that what's going on in the trial court's order?
Yes, the trial court is stating that. The trial court basically only made the statement that this is not enough. Low risk is not enough for this child.
Against a backdrop of recurrent problems, even after the recommendation is in.
And that's correct, Your Honor.
So that's beyond just parroting, isn't it?
It's not. It's actually just parroting, because the department in this case, Stephen Garvey, the juvenile probation officer, was present at every disposition hearing. And Stephen Garvey got up. He was familiar with the 2 new charges. He was familiar with the plea from the initial disposition hearing to the contributing to the possessing the alcohol by a minor. So the Department of Juvenile Justice was aware of everything that was going on with this child, even the current charges. And if the Department of Juvenile Justice is already aware of that information, has already considered that, they did not change their recommendation. They still recommended a low-risk commitment program. So in order for the trial court to deviate, they must explain the reasons why they are deviating from that. They must explain the reasons why they are not going to go along with the department's recommendations. And in this case, they did not identify a significant characteristic that either showed that the department had misconstrued something, had overlooked something, which is the requirement that has been articulated by the Florida Supreme Court as well as this court. So as to, and I know your honors were referring to the new charges, and we can simply look at JH, which is an opinion issued by this court in 2012, and in that case, there was actually a new burglary that had occurred while they were awaiting trial on an existing burglary. And this court noted that the DJJ was aware of that. They didn't ignore that fact. They factored that in. They made their recommendation. That, in and of itself, as well as the information that was already provided by the DJJ through live testimony, as well as throughout the extensive reports, is not enough. It's merely not enough to just restate that information.
So all you're really seeking, though, is a new disposition hearing, it sounds like.
Yes, Your Honor, and if there are any reasons that could support that aggravation. However, if not, then in accordance with Bryant, then it needs to be what the DJJ recommended, which is the low-risk commitment program. And I'd also point to RCB Jr., which is another case from this court, where LaRose authored the opinion and Morris concurred.
I think it would be better if you refer to the judge that's authoring the opinion as Judge LaRose rather than just as LaRose. If you could do that for us, please.
Okay, no problem. Thank you. So in that case, Judge LaRose authored the opinion, and Judge Morris was the concurrent in RCB, and in that case, it was an aggravated battery with great bodily harm case. And the trial court in that case also failed to explain the reasons why they should depart, and they also failed to address the reasons why public safety was important. And this court, in this case, the trial court didn't even address public safety at all. It was left completely off of the table, and that is directly contra to what EAR and its progeny stand for. So in this instance, the trial court failed to articulate an understanding of those different restrictiveness levels, and also failed to logically and persuasively explain why, in light of those opposing restrictiveness levels, a deviation would be necessary. They did not identify that significant characteristic as to something that the DJJ may have overlooked or misconstrued or didn't pay sufficient attention to. They just merely stated what EAR stated that you should not do. They merely came in and said, well, I think this program is better, so I'm just going to put that child there. The only thing that comes remotely close is the written order that was issued 15 days after CD filed the notice of appeal. And in that order, the judge did make reference to that there is a higher and more intensive substance abuse and mental health programs available at the moderate risk level. However, there's no evidence presented at either of the disposition hearings that support that finding. So that was just something that basically came out of the court's head. The court did not discuss the moderate restrictiveness level with the juvenile probation officer, Stephen Garvey. The trial court in this instance simply asked about low risk, seemed to get very hung up on the fact that the minimum housing was about 45 days, and then asked how she could then deviate from that. Also, at the disposition hearing, towards the end, the child's father, who is a party to this case, wanted to make a comment, and the judge did not allow that comment, which is contra to 985.4334D, where all parties are permitted to make comments on a child's disposition. So that wasn't allotted, that wasn't followed.
That's not an issue here, is it?
That's not, it's just something additional to consider because the court, well, it actually is, Your Honor, because the court is to consider every single thing about that child, and the trial court can consider live testimony. And it's obvious that the father clearly had something to say. Defense counsel filed a motion after that hearing, which was summarily denied by the trial court, stating, look, this child really needs to get home. The first disposition hearing was continued to see if we can work this out in the community. We've taken those steps. We have the child on medication now, so he no longer has untreated ADHD. We've applied for Medicare for this child so that he can have insurance to get this treatment. We've contacted DACO in Phoenix House again to see if he can get enrolled in substance abuse programs there. but the judge didn't even want to hear any of that. And they even also came to the second disposition hearing with copies of the child's prescription bottles to show to the court that he is now on prescription, but the court didn't want to hear any of that. This is also something that has been articulated recently by this court. The standard is very clear. I don't believe there's any contention as to the standard. And it was recently articulated in DG on March 25th of 2015, wherein Judge Wallace concurred in that opinion as to what is necessary in order to depart. So in closing, when departing, the juvenile court may not simply repeat the information that is known to the Department of Juvenile Justice. That's not what EAR and its progeny stand for. The court is supposed to come in and look at all of the different restrictiveness levels, ask the expert, the department, their questions to get a better understanding of those restrictiveness levels, and then articulate an understanding of those levels and explain why their level is better suited. They did not explain why their level is better suited. They did not even inquire as to the moderate risk commitment programs. So if there are no further questions, I'll rely on my brief.
You've got your 5 minutes left for rebuttal, Ms. Brookins.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Cornelius Demps on behalf of Pam Bondi, the elected Attorney General, and I represent the state of Florida in this proceeding.
So the trial judge didn't tell us much, did she?
Well, Judge, you know, I think that's...
Question is, did she tell us enough?
Well, Judge, I think on the face of the order, looking at the order, there may be somewhat of a deficiency of what the trial court found. However, those deficiencies not found on the order are apparent on the face of the record. And that's based on the testimony that was given to both the DJJ representative at the February 27th proceeding as well as the March 20th proceeding. I think that's important to realize that on January 21st, the appellant in this matter is first adjudicated on the burglary of conveyance and a petty theft. There's a 30-day continuance. During that time, DJJ does the predisposition report, the PDR, and the comprehensive eval. At the February 27th proceeding, over the state's objection, a continuance is granted to allow the appellant's family to try to find a way to help deal with some of the other issues he was dealing with, namely the ADHD. In the interim of that hearing between February 27th and March 20th, that is when the appellant picks up for 2 brand new law violations. And as the state is arguing before, that is important because those violations are significant to the extent it illustrates that the appellant in this case has a continuing pattern of drug abuse, alcohol abuse, and criminal activity. That is also important because not only does the DJJ do the PDR evaluation and the comprehensive evaluation at the February 27th proceeding, but at that proceeding they already review and say, well, we're going to recommend low risk. However, the fact that he commits new violations down the road that are drug and alcohol related further show that DJJ did fail to sufficiently consider the rehabilitative needs of the appellant at the time of their evaluation.
Low risk would require outpatient treatment.
Yes, Judge.
Does it require the child to stay at home?
Yeah, it's an option, Judge. Yes, under low risk as well.
And in the interim, what you're telling us is that option is not working.
It's not working, and that is yes, Your Honor, and that is also based on the significant history that he's shown of not being able to fully complete outpatient treatment programs. That he went to Phoenix House. It's also important to note as well that when he's removed from Phoenix House, in the discharge papers in Phoenix House, page 78 of the record, in their reason for discharge, Phoenix House writes, quote, excuse me, let me make sure I get this right before I say it. They do note, quote, needs to be reassessed, inappropriate placement. So at that point, Phoenix House has themselves seen that he's not going to be a good fit for him to be placed in that type of facility. Now, under the EAR analysis, it's important also to remember that the standard review pursuant to the statute is an abuse of discretion, which means, to paraphrase or to make it rather short, would a reasonable judge in the same position as this trial court have also disregarded DJJ's recommendations? And I think that is exactly what we have here in this case. The burden of proof is a preponderance of the evidence. So based on the fact that he commits new violations after the PDR evaluation, where they say that he only needs low risk, the new violation shows that by preponderance, it is more likely than not that he needs to go to a better facility other than the low risk that's being afforded to him at this time. It's also important to note that during the hearing on the March 20th and February 27th, at one point the trial court specifically asked DJJ on the record what exactly is offered at a low-risk facility. And the DJJ representative, Mr. Garvey's response is, quote, "They offer minimum wraparound services to treat his needs." I think the trial court then takes that into consideration to determine that minimum wraparound services is not going to be enough to resolve the rehabilitative needs of the young man in this case. Now, to follow up on some of the questions that this court asked earlier regarding Judge Morris's question, how much more detailing is necessary to be inside of that order? Again, I would think that on the face of the record, we have those details are present. You have a young man who's been evaluated. He has a significant history of possessions of marijuana, petty thefts, a burglary of conveyance, possessions of alcohol. And in the interim, after the evaluation, not only does he pick up a new possession of alcohol by a minor offense in Hillsborough County, but he also picks up a possession of alcohol and an indecent exposure offense in Pasco County, where he's caught not only being intoxicated, but also urinating on the side of an elementary school. So with that, I think the real question is are there necessary a bit of magic words that the court has to articulate to come to its order? We would say that no, if it's apparent on the face of the record, we think that's fine. To follow up on that point as well, Judge Wallace, recently, as the appellate did cite, this court did decide the DG case, where this court did rule that the trial court did abuse its discretion in departing from the DJJ recommendations. But it's important to note that in the DG case, the trial court was found to abuse its discretion mainly because it only considered the PDR that had been evaluated. There was no comprehensive evaluation that was ever done. And this court did go into significant detail to note that that is one of the main reasons why we feel the trial court did abuse its discretion. How can it make its own recommendation without considering the other evidence which it's required to do so? Here in this case, we don't have that. We have that DJJ's done both of its evaluations, has seen the issues of the appellant. They feel that DJJ feels that this is the best that's for him, but subsequent to that, he continues to present problems down the road. And also, Your Honors, as a practical point as well, it's important to note that when the CD in this case is adjudicated, he is adjudicated sometime around April of 2013. In July of 2014, the new statutes eventually go into effect. The 2014 statutes under Section 985.03, subsection 44B, specifically notes that the low-risk facility and a moderate-risk facility are now merged into what's now known as a non-secure facility, and that's found within the face of the statute. So looking at this, if the court were to find, well, there's not enough in this order here, we are going to remand it down to further proceedings, either one of two things would happen. One, the court makes those findings, and he goes back to a moderate-risk facility, which is a non-secure, or the court, as the appellant noted, under EAR and under Bryant, the court has to go with the DJ recommendation to send him to low-risk, which is still the same non-secure facility that he would be in this place. And Your Honors, there are no further questions at this time. I will rely on the brief in this matter.
All right, thank you, sir. All right, Ms. Brookins, you have 5 minutes remaining for rebuttal, ma'am.
Thank you. The appellant is not arguing that a court needs to articulate any sort of magic words. The appellant is only arguing that the trial court abide by EAR and its progeny, which the trial court did not do in this case. The trial court was completely deficient in even addressing how a moderate risk program could ensure the safety of the public to prevent further delinquency of this child as required. But in addition to that, the trial court is also somewhat deficient, as Judge Morris has stated, and just basically stating just basically parroting what the Department of Juvenile Justice already knows. Appellee's argument is basically that the two charges are significant enough to change the trial court's mind. However, this court has held, the Florida Supreme Court has held, that information known by the Department of Juvenile Justice, which it was clearly known by the Department of Juvenile Justice based on the live testimony at both of those disposition hearings about these two charges, that Juvenile Probation Officer Stephen Garvey was present at both hearings, that Juvenile Probation Officer attested and testified to those two new charges, and that Juvenile Probation Officer did not change the recommendation. The recommendation was still a low-risk residential program. Also, as to the differences in the low risk and the moderate risk program, the statute, as it stood at this time that CD was committed, it's not a stay-at-home type of placement. I know Judge LaRose, you asked that question. It's not a stay-at-home. There is some allowance there may be some unsupervised access to the public, but it's most definitely not a stay-at-home facility. So I did want to make that clear. Also, it was brought out that the Phoenix House thought that that was not a good placement for the child and that he couldn't get the appropriate services. However, that's incorrect because the father had contacted the Phoenix House and stated, and the Phoenix House was willing to accept the child back into their program. So the Phoenix House did not believe that that was not a good fit for that child. If there are no further questions, I'll just rely on my brief.
All right.
Thank you.
Thank you both.